All right. It is a 21st day of June, 2024. It's 9 a.m. We are in the Commissioner's Courtroom in Aransas County Courthouse, and I call this workshop to order. Roll call, please.
Commissioner Cheney, Commissioner Casterline,
Here.
Commissioner Russo,
Here.
Commissioner Dupnick,
Here.
and Judge Gottison.
Here, we've got a quorum. Item number 1, discuss the Aransas County subdivision order and related development regulations. Miss Catherine, sorry.
Good morning.
Good morning.
Morning.
All right. Thank you all so much for the opportunity to talk to you all about some of our development regulations. The packet that was for the workshop today, the first couple of pages, I just wanted to talk about the basic outline of what a county can do. So the statutes that are listed there are the state regulations that we look at specifically for county regulation of subdivisions or replatting property. And so the most important thing that I wanted to emphasize is that since we're a county, we have to have a clear statutory reference or a clear case law precedence whenever we want to adopt a regulation for development. Very different from a city. The cities in Texas, home rule municipalities, have been given a lot more authority. They can adopt a law as long as it doesn't contradict the federal and state law. For us as a county, we have to look at what the state constitution says we can do and what our state codes say we can do. And so the Texas Local Government Code, Chapter 232, is our primary bit of legislation that we look at for county subdivision regulations. But I also wanted to include the Texas Administrative Code because that is very applicable to our regulations. That is the state regulations for on-site sewer facilities. And yes, that gets regulated through environmental health, but when it comes to subdivisions, that is something that the state says, hey, if you do not have public water or public sewer, we have specific regulations for how big the lot can be or how small it can be. And so that's where that Texas Administrative Code comes in. The Texas Transportation Code is where we get the authority to require that for a new subdivision that the developer has to put in a roadway and drainage that would meet the county standard. We cannot require anything more restrictive than what we require ourselves to do. But that's the provision for our infrastructure requirements and the Texas Water Code. This particular provision is often erroneously referenced by other counties as a federal provision, as the FEMA Act. It's not. It's a state water code, but it is where counties are given the authority to enforce what we need to participate in the National Flood Insurance Program. And so that ties into everything for us as a coastal county. And on the next page was just a few of the criteria that ties into how those statutes, like how we're eligible to use those statutes. As a coastal county, for one, that's something that Chapter 240, subchapter Z, we wouldn't be able to use if we were not directly on the coast. Our population size is also very relevant. When you go through the state statutes, sometimes it'll say the only counties that can use the provisions are going to be urban counties or have to have a specific threshold of population. So for us, we're considered rural. Our population is estimated last year to be at about 25,000. We are the 6th smallest county in Texas, based on land mass. Half of our county is in the water. So very, very pertinent to our regulations as far as the how we regulate development. So the first topic, I narrowed it down to 4 topics that I wanted to get y'all's input on for the subdivision order. I'll be bringing back the revisions for us to look at in for adoption. But since these have come up, these are specific topics that have generated more discussion, particularly flag lots. So flag lots are weirdly controversial. In an area that does not have public water and public sewer, they're very popular. It is a way for property owners to subdivide their property without having to do infrastructure work before. It's also a way for low density development to be accommodated. We are very low. We do not have a lot of what they call grade. We don't have a lot of fall. We don't have a lot of change in elevation. And that makes public utility extensions very difficult. And so flag lots are one of the reasons I'd like to discuss this. Is I would like to see if y'all would be amenable to allowing flag lots, provided that we had specific parameters. And so that's where those examples that are in there that say specifically, and I'm not saying that we should adopt specifically what these examples say, but I would like to set some sort of parameters so that we can allow flag lots to some extent. The expansion of city utilities or of public utilities through municipal utility districts is a very expensive process, and it is very much what we want to hope to happen, but it's something that in a lot of the unincorporated county is not very feasible. So on flag lots, is there any specific, the biggest concern tends to be the staff portion of the lot, which is the driveway. It is not a road. It is specific. I just want to address that specifically. The only way that it would become a road is if on the plat or on a separate type of instrument that was filed, where it was identified as a public road, as a public easement. Only then would the commissioner's court be required, or would the county be required to do maintenance of any kind on those driveways. And so that's come up before, but I just want to clarify on that point. We can require for fire safety that the driveway be a certain linear footage. We can require that it be a certain width. And we can require a certain amount of compaction in order to accommodate emergency vehicles. But that is what we can do. What would the commissioner's court, do you have any specific concerns?
Kat, I
Yes,
was thinking that there was a state requirement that part of it that came to the road had to be 50 feet wide.
It's not a state requirement. It does have to have access. That's the main, we cannot allow a subdivision to create landlocked lots.
Right.
But as long as it has access, then it can be allowed with that.
But I would think we need to set a width. And to me, of course, you have ambulances, fire trucks and things like that, which when you granted a construction permit on the property, it seems to me like you would have to make sure that they had ample access for ambulances and fire trucks or whoever needed to go down there. I don't really see a problem with having them myself, as long as you have some things.
My question, if you
Go ahead.
my question is, I don't see what the benefit is to the community. I see what the benefit would be to the developer, but I don't know that the county is in the business of helping out the developer. And it says in what you gave us that the problem is that staff or the skinny part of the property falls into disrepair and presents an issue for emergency responders. And I know I have very little in my precinct that isn't within pretty much the city, but the areas that do fall outside of the city, I have unplatted subdivisions and I get calls about poor quality of the roads, just any number of issues that they have there. And I don't see why we would want to create more problems for ourselves. So I don't see where there would be any benefit to anyone other than the developer.
I don't
But
think
perhaps
a
you
lot
can
of
tell
time-
me where there's a benefit.
A lot of times flag lots are not a developer, but maybe somebody that owns a piece of property. You have a lot of them that are actually a division within a family. When
Yeah,
they get to a certain point and they split it amongst their kids, and that's a lot of.
We just approved one recently, didn't we?
Yes, sir. Yes, we did.
Proved it. We had a regulation that it had to cut front come to a paved
Right.
road
Right.
and
Right.
change that.
Yep, that's where we had to do a variance in order to do it. And that is, but that is correct. Like most of the flag lot proposals that come up, when I say developer, we use that interchangeably, like for a big developer with a little developer.
So
But
do I.
and for this, I do, it is more accurate to say that it tends to be families that have had the property for a while, that once they've inherited it, they are wanting to build on a portion and then finance part of that through selling the rest of it, or to just
Yes.
subdivide it and sell it. And so it does tend to be the smaller family type operations that request those types of flag lots. The bigger types of developers who are property flippers tend to want to get as many lots as possible. And so they'll want to have the benefit cost for them tends to be more on the side of going ahead and putting in a roadway of some kind in order to create more lots. But that is a very valid concern and something to look at as far as like any type of long-term maintenance plans that could be looked at, or some type of way that we could have long-term oversight on driveways to prevent that from becoming a community burden.
Yeah, family subdivisions have some kind of exemption. I don't remember what it is. Can you kind of hit on what?
Yes, sir. So in chapter 232 of the local government code, the state does have exemptions. And so if someone wanted to subdivide their lot and sell it, deed it to a family member, and it's any person within a third degree of consanguinity. So if they're doing a family transfer, they don't have to come through commissioner's court. They could have the property subdivided through meets and bounds, and they wouldn't have to go through any sort of county. They would have to, typically they do go through us because they go through the county surveyor's office, and we do make sure that they have filed with that meets and bounds the documentation necessary to prove that exemption. But they would not have to come through the court for if it is to family. The main thing, reason they want to do the formal replat is they want to put the property on the market and try to get an outside seller.
Yeah, I ran into something in my precinct that somebody in their family had a lot behind there, so it wasn't a flag lot, but they were tapped off the same city water, and at some point they wanted where they could have 2 meters. And I think the city made them create a 50-foot wide easement, basically turning it into like a flag lot. So we might want to check the city regulations on, since they have water and gas, I would assume they require that on one or more of their utilities.
Cat, I know on the west side of Spanish Wood, there are some large lots, and they're in the city limits where the city specified that they had to have certain kind of driveways. Didn't have to be concrete, but they had to be a good solid base. And I'm just wondering if we were to allow these, if we could specify that they have, of course, it doesn't take care of maintenance, but they would have a certain kind of a driveway or road base in case EMS people did have to try to get to the back of those lots.
Yeah, that's kind of what I was talking about on, maybe we should do that when somebody gets a building permit to build a house or a shop or something.
Absolutely. Now we can definitely look at considering if they have public utilities that will require an easement, that may preclude them from needing a flag lot anyway, and would be something to look at. But so definitely we'll incorporate that. And the city, the way that we can require driveway specifications ties into the county fire marshal can require that the planning documents and the development be done in accordance with any state or federal fire code. And so that's where what we would look at is a fire code provision that has been adopted by the state. And then we would just need to incorporate that into our subdivision order. All right. So I feel it's like I got a pretty good idea on the flag lots. Was there any other discussion?
On 188, east of 1069 and north 188. There's some, and I always thought they were flag lots. There's a little subdivision and there's got a bunch of little acreage limited to certain sizes because, and they're over 1 acre because with the different rules considering water and sewer and everything, because they're all sufficient. And I was curious if you look into that and see how those drives, if they fit the flag lot qualification, how do we get them approved? You know, were they something that, was there something in place? But basically it's that area between the bypass and 1069 and south of 188.
I will have to look and see.
Yeah, it doesn't really have a name, but the gentleman, he developed it. There's quite a few acres he developed in there. And I think it had to be like, I can't remember the acreage, but because he had water and septic self-sufficient, he had to have so much size, but they have access and basically it's lanes. And I'm just curious if there was some kind of how we allowed that.
Well, I, depending on when it was platted, it could have been platted prior to the county's adoption of the requirement of that
Okay.
50-foot frontage.
Okay.
It also, if it was platted after the county was in an interlocal agreement with the Aransas Pass, if it's in their half-mile ETJ, there's a lot more flag lots there because those plats go through their approval process and there's nothing in their zoning that specifies.
I was just curious if we had something in place already somehow from that might be
I
able to.
think that there might be a private road going into that. That's the place I'm thinking of.
Yeah, that's what I was wondering. If those weren't designed as flag lots and,
When they create a subdivision, they can have either private or public road.
okay. So that's probably what
If
guided
they're
that.
gonna be public, they have to be to our spec.
Right. Okay. Okay, thank you.
All right. And so very similar, the next topic I wanted to run by y'all, minimum lot sizes. So like I said, the Texas Administrative Code, if you've got septic and a water well, the state has very specific requirements. You need at least an acre if you don't have either public water or public sewer. You have to have at least half an acre if you have public water but have a septic system. But if there is both public water and public sewer, there is no clear statutory provision that says what minimum lot size we can require. So different counties have different approaches. Some counties have done away with the minimum lot size. Some have just changed it to be less restrictive. Currently, what we require as for if you have both public water and public sewer is 1/4 of an acre. And so that's that. I would like to revisit that. I would like for one of the reasons these specific topics were chosen are what we see come before y'all as variance requests most often. And one of those would be if we don't have a lot of areas that have both public water and sewer, but if we do, any replat tends to need to come through the variance process, even if it's part of a planned unit development previously. And so I would like to propose a less restrictive minimum lot size on public lots with public water and public sewer so that we wouldn't have to come through y'all for what should be probably be more administrative type reviews.
I don't know if it was David Reed or David V that even though we have that stipulation of size that they had thought in the past that we really didn't have the authority by law to make that, to impose that regulation. So maybe you need to try to check and see if we can figure out if we actually do have the authority or not.
As that is my concern as well.
But you said we don't get very many requirements or requests for people to get the variance for this. I know what I've seen mostly are people have either 2 or 3 lots and they're trying to combine those, either cut the 3 into 2 or merge the 2 into 1 so that they can have a larger lot to get the OSSF on. But it's still under what we require, and we usually grant those variances without any kind of issue. So I don't know where the benefit would be if you aren't getting very many requests that fall outside of that, why we would want to establish a smaller lot size.
Well, honestly, like Commissioner Casterline said, one of the big concerns is, can we even require a minimum lot size when there's public water and public sewer? The state provisions and case law we have to be careful of not regulating based on land use. We have to be careful of using any regulations that could appear to be zoning. And that's one of the big concerns. You know, we can set a smaller minimum lot size. But we definitely, I think, should look at what we can do as a county. Aside from, we don't have a lot of areas with both public water and public sewer. For example, though, like Islands of Rockport, we've had a couple of replats where they have both the water and sewer that have been brought in. And we have a few newer subdivisions that have extended both sewer and water to their lots, and any subsequent replats with any requests from those property owners, they may, if they want to do a smaller lot size, that's the big question. Do we want to have a set standard if they don't have any restrictions from the state?
Don't most of those new ones have homeowners associations that would have to go through before it came to us?
Well, and a lot of the homeowner associations, typically the plat comes through us first, and then they take it after our approval.
That's what I mean, but if it's after the fact, I would think that it goes through them before us, that if
I got to admit, I think it's different I know with Holiday Beach, we do the approval first, but now that I think about it, Islands of Rockport, and I believe Sunset Bay as well, those would go through their property owner, homeowner associations first.
or now they have their paperwork drawn up.
Yeah, and honestly, that would be one of they do tend to be with subdivisions that have active HOA and POAs. And so that would enable us to try to make any type of replat would allow that, having administrative ability to approve the lot sizes based on what is the neighborhood standard versus what utilities are available when all utilities are available. That would remove having to bring variances before y'all. I'm sorry, I completely messed that entire sentence up.
No, I understand. But so I'm just curious. So what Commissioner Casterline is talking about, if the POA or HOA of that neighborhood makes a decision about what the lot size is, does that trump what the commissioners approve or disapprove?
No, ma'am.
Okay.
It would,
It would still come to court, but we could take a look at what they have wanted to establish for themselves.
yes, ma'am.
If they didn't want to do it, it probably wouldn't come to us,
Okay.
what I was thinking.
Adela, can you look see if we even have the power for the public water and public sewer? Okay.
You might even have to get an AG's. I would try like Jim Allison with tech. He's kind of like a computer. You ask him those kind of questions, he can usually tell you where it's at in the code and all that kind of stuff.
I could see a potential need for this flag lots. I think, and Bubba, you might be more versed in this, but I think especially in a lot of the area on the south end of the county, there are a lot of tracts of land that are narrow and deep. And I could see as time goes on, for different reasons, people would be trying to, break those lots up as individuals the most cost-effective way. So I could see where this might be becoming more and more something we might have to address.
Yeah, I think the flag lots, we should leave ourselves the ability, but set some kind of guidelines why you wouldn't do it if somebody wanted it.
Move on to county standard setbacks.
Yes, indeed. And this is very similar discussion point as the minimum lot size. The county standard setbacks is 25 foot front and back and 8 feet on either side. And what I would like to bring forward as a amendment to our subdivision order would give staff a little bit more flexibility on setbacks, or would allow for, like, if we have a corner lot, slightly different setbacks. If we have both public, if it's a smaller lot that has public utilities, having a slightly smaller setbacks. Again, it's one of the variances that tends to come up whenever, like Holiday Beach, they have a replat for septic compliance. Then we have to put in that little additional variance request for the setbacks to match neighborhood standards. And that I would like to be able to have a little bit more administrative flexibility on that, but I wanted to see what the commissioners had thoughts on that would be.
I'm okay with the
Yeah.
current 25 and 8.
Yeah,
I
I'd
am
be a
too.
little reluctant to make it any closer. That 8 on the side is pretty tight.
And this only affects properties that have been, if the changes we make affect properties that have been platted after the subdivision regulation.
It would, yep, it would only
Yeah.
affect going forward.
Yeah, if it was
Yeah.
platted 20 years ago, I mean, there's no,
Correct. Yeah,
rules? Okay.
we don't have a way to go back and retroactively require subdivisions to comply. It is. The city's setbacks are all based on zoning. And so theirs are very, very different depending on the type of use and what zoning district that they're in. And I want to say that it is less for residential, but it can change. They have a few different types of residential zoning districts. And so depending on single family, I want to say it's like 5 feet for side setbacks, depending. So there's definitely a lot of variety in how setbacks are regulated. It is, again, just one of the things that tends to come up whenever variance requests are brought to commissioners. But y'all are fine with that coming back if someone wants to request a variance on that, then
Yes, rather than changing what we have.
Right.
Yeah.
all right. Well, and the last topic is variances. And really, I really wanted to just make sure that y'all would be amenable to a amendment that would include specific criteria so that whenever a variance comes before y'all, there is a checklist of some kind where we are saying, hey, we've checked to make sure this is not going to, set a bad precedent, be unsafe, that it still meets the intention of the county subdivision requirements. And so, but the examples, like I said, I'm not proposing these exact examples be adopted, but they're good examples for the type of parameters that we could set. And so any type of parameters that y'all would like to see, I would love to know.
So are you saying we have no criteria now?
We really don't. We have the mechanism to request variances allowed in our subdivision order, but we do not have any specific criteria outlined.
I think if you do the right guidelines, that's a great idea, because as time goes on, the court always changes members. And this way you have consistency for the public.
Yeah, maybe even list in it examples of why they've been granted in the past, or ones that would be favorable anyway.
That is indeed one of the reasons I'd like to have this update. Whenever we look at plats that have been done in the past, if we don't have someone, which luckily we do have, a lot of information from Mr. Brundrett whenever it comes to a lot of the plats, but if they were done by someone else and they were not done when someone who is here now was there, then there's a lot of times where it's kind of, we don't really know what the thought process was. And having something codified that we could even possibly require like some sort of filing with the plat that would say, outline, include that checklist, include those reasons. We have minutes and stuff that I know that that if someone wanted to, they could go through and find the commissioner court minutes where some of these variances were discussed, but it would be, I think it'd be good to have some kind of document with the plat that would help with that understanding of that process.
think that's a great idea.
You want, yeah, you have to come up to the podium.
You have to,
Come up to the podium, please. State your name and your address, sir.
Ken Barron, 402 Cascades. I'm on the architectural committee at the country club. And I'm familiar with all the deed restrictions there, and they have setback requirements. And they also have examples of variances. For example, if you live on a cul-de-sac and you have a pie-shaped lot, you may not be able to meet the requirements of the setbacks when you have a strangely shaped lot. And that's an example of where you may get a variance granted. So they provide some examples like you're talking about.
That's good.
Okay,
So
appreciate it. Thank you.
I
Appreciate
think
that.
that'd be a good idea.
That's exactly the way, what we're looking at. And so I'll be bringing y'all drafts of these amendments for y'all's consideration. I really appreciate y'all's input. This has helped me a lot. Thank you.
Thank
Thank
you.
thanks, Ken.
Thank you,
Thank
Kat.
you.
Great job.
Appreciate you. Thank you. All right, we'll move on to item number 2, discuss the Texas Association of Counties Health and Employee Benefits Pool Plan for 2025, the renewal rates. And we got Desiree.
Good morning.
Thank you. Good morning.
So as you know, our rates are going to increase this upcoming year. So I just created some spreadsheets to show options that we could go with. This first page, I circled the 2 plans that I included in the options. So the first is the renewal rate, which is the 8.9% increase. And then the option 1 plan 1100 NGS is about a 5.5% increase to the rates. Okay, so for the first spreadsheet, where the employer pays the entire portion, employee portion would be at the bottom. The red section says employer pays entire employee portion. So I'll just go through each table. The blue table is the renewal rates for the 8.9% increase. And the green table is the option 1, which is the higher deductible plan. So I broke it down by tier. That's the left side. So employee only, employee and spouse, employee and children, employee and family. So this is what we currently have for our tiers. Our current rates are to the right of that. The new rates under this plan are next, and the increases on the side of that. So for this, the employer, the county, would pay $853.62 per pay period, which covers the entire employee portion. Then it shows to the far right of the blue table what this is per pay period for the employee. And then out to the very far right, not on a table, the current amount the employee pays per pay period, and then this would be the decrease that they would see if we went with this plan. And below it, the next table would be the total increase that the county pays per year. So it's broken down again by tier. The total would be $306,752 per year that the employer would pay. So all of this information then translated down to the green section would be the higher deductible plan, and the county's portion would be $244,437 per year. And then the employees' rates would also decrease. So I have 4 different pages. The next one would be decrease the employee portion by 50%. So instead of paying $30 per pay period, then they would be paying $15 per pay period. And then again, on the next page, employee portion decreases by 25%. So instead of paying $30 per pay period, they'd be going down to $22.50 per pay period. And then on the last page, the employee portion remains the same. So they'd still be paying the $30 per pay period. And then it shows the total cost for the county also decreases. Do you have any questions on these 4 pages?
Just to be clear too, we are only paying when the county's portion is only for employees, correct?
Yes,
No dependents.
correct.
And those squares highlighted with the dark the dark square, that's the bottom line.
That's the
basically.
bottom line.
That the county would, yes.
That's what we're gonna agree to, pay.
Depending on which option we select.
Yes, ma'am.
Yes.
So I had looked at what you had given us previously for this morning, and my preference is the alternate one, option one, where the employee continues to pay the $60 per month that they have been paying. But
Okay.
actually, if they have dependent coverage, they will be paying less than they're currently paying.
Yeah.
Yes.
And
And
I know that's because the deductible has gone from 500 to 750. But like I said, I think there was some concurrence. Most other companies have deductibles of 3,000 to 6,000 or 7,000. So to keep it at $750 is still quite a benefit. So this allows the county to still absorb the additional cost, but we go to a slightly reduced benefit plan that's still very attractive. And if they have dependent coverage, the employee benefits because they actually think we'll be paying slightly less.
Yes, and also to go with that higher deductible, only 25.3% of employees and dependents met that deductible of 500 last year.
Yeah, and thank you for providing.
yeah, appreciate
right.
that. So
Yes.
that means basically this would benefit 75% of the employees who have
Yes.
dependents.
Yes, and then 5.6% of employees came within $200 of that
Very
$500
small percentage.
deductible. Yes, so it's not affecting the majority of employees. And then
This is
also,
This is Misty, Kimbrough Aransas County Clerk online. My concern is for the 25%, some of which are single parents who carry their children. That higher deductible is going to change what they can or cannot buy at the grocery store. I just want that stated and heard and on the record.
yes, and I did think of that. So with the 8.9% increase compared to the 5.5% increase, employees are going to get a reduction in their premium by going with the higher deductible plan. So the savings for employee and spouse from going from the 8.9 to the 5.5 is $224 per year. So that really offsets the $250 increase for the deductible. Then employee and children.
And that deductible is per person, correct?
Yes,
Yeah.
and the employee and
And so
children,
if you're a single mom of two,
can I finish?
that's-
So the
yes.
employee and children portion is $124 savings, so that's half of the deductible. And the employee and family savings is $308, which is more than the deductible.
unless there's three people meeting the deductible.
It's
Again,
still a
though,
savings.
over 90% of the this will benefit over 90% of the employees because you said only 5% came close. Those-
Yes.
So
Well, 5% came within $200. So 25 met the deductible, and then an additional 5.6% came within $200.
so this is going to benefit the majority of
Like
the employees.
70%.
There's some are going to suffer, have a hardship, but you're also saving money up front on what they're paying for their insurance.
Per year, yes. So if they don't even meet the deductible, they're saving money.
Yeah.
So, there has to be compromise somewhere. We
Right.
can't pay the $306,000 for everything.
May I add something?
Yes, ma'am.
Just in what she's talking about, the deductible only applies when you actually go into the hospital or something. If you're just going to the doctor's visit, you're going to get prescriptions and stuff, that deductible doesn't apply. You don't have to pay a deductible to meet those. Am I correct, Desiree?
I'm not sure exactly how that works. Clarice would be better to speak on that.
Usually it's just a copay whenever you go to just a doctor's visit or you go get your prescriptions. And most of those, a lot of them are at zero if you get generic. So your deductible comes into play most of the time with most insurances when you go in the hospital or you have some kind of procedure like that. It's not just for your normal doctor visit.
Right,
So-
or lab tests.
And our standard benefits aren't changing between the two plans, correct? As
Correct.
far as,
Oh, no.
yeah, so, but they're still getting the same benefits from that.
I
And-
think the emergency room increase is like $50 per year. But I would like
I
to,
didn't understand what you said.
I believe the emergency room portion increases like $50 per year between the two plans. But it's shown here on this sheet,
It-
all the
It
differences.
says it's still 30. Okay, it did.
The hospital, sorry, the hospital.
Okay, yeah. And one concern might also be, and this is just a point of education. So maybe we could get Clarissa or Tack in to do that. My husband has worked at a pediatric clinic for over 20 years. And a lot of parents take their kids immediately to the emergency room at Driscoll, where they sit for 3 to 6 hours. And it would be better if they went to the urgent care and really had something done. The only reason to use an emergency room basically is if they're bleeding or they have broken bones. Other
Yes,
things urgent care can take care of. But I certainly have seen a lot of employees here and other places use the emergency room as their primary care physician. And that's when you run up high bills.
yes, and that's something we do need to educate our
Yes.
employees on. I agree. I would like to say my recommendation would be the higher deductible plan with the lower rates, but where the employee is now paying the 2250 per month. The increase for the county would be 138,000 compared to the 102. And the reason I say this is I did a report on which eligible employees received their step increases this year. And as of this past pay period, only 23% of eligible employees have received that increase. And I excluded elected officials and I excluded poll workers from this number. So that means 77% of eligible employees haven't received an increase this year. So not a COLA, not a step increase. And then if we throw a higher rate for the insurance, that's just hitting them with a lot. So I just wanted to throw that out there. And another thing, I went back and looked at our surplus distributions, which are our refunds from TAC. Since 2019, we've received $278,900 about in refunds. And the county absorbed that back into the general fund. And since then, the employees' rates have increased or stayed the same or increased. And I compared the numbers for what the county's portions increased compared to the employees. Employees' rates have increased 33.3%, and the county's portions increased 6.6%. So this is another reason I'm proposing that we try to lower the employees' rates down from the 30 per month to the 2250 per month.
You're saying this would be a positive thing for the employees overall?
Yes, it would.
I like the fact that you did all those calculations. So it's a good thing you had all that accounting in your background. I think again, though, it goes back to educating the employees, and I commend you for what you've done since you've come into office or
Thank
come
you.
into your position. A lot of the surplus that we used to get back, I know when I was the HR director, we were receiving very healthy checks for several
Yes.
years. And they're based on the previous 5 years before that. And I think what we had was a loss of education where employees didn't really know what was covered, why they should get annual checkups, and to stay away from the emergency room unless it was an emergency.
Yes.
And although that's a $36,000 more bump up, I like your rationale and could maybe support that idea, but I think it has to be contingent with educating our employees.
Yes, I
So they
agree.
know how to use their insurance.
Yes,
Because
the
they
judge
used
and
to be
I,
very familiar with it. And
yes,
now
ma'am.
I don't think we have that knowledge.
The judge and I have talked about implementing a wellness program beginning next year, just because the time period is so short right now.
Right.
That is something we're working towards. And for the health fair, we want to educate more than we've done so in the past. So it's on our to-do list, on my to-do list for sure.
One thing I learned is there's an option, a teledoc.
Right.
So if you don't feel well, you could call the doctor on the phone and he could send you a prescription, tell him what you're feeling.
Right.
You don't have to leave your house.
Which
except
is
get you-
exactly what they did during COVID.
Yeah,
And there's also a 24/7 nurse line that's
Yes.
free. It's covered. You talk to them and they can tell you home remedies or suggestions. So,
And they'll usually refer you to consult your primary care physician, but it takes care of your immediate need
yes,
instead of going to the emergency room.
yes. Do you have any further questions?
Well, I didn't think I was going to change my mind, but I could change my mind to where the employee is paying the $45 a month.
And this would be
Just one person.
what y'all did for years. So this is what y'all did for years. Y'all paid 40 to 45 and then it increased this past year.
Right.
And so if we left it, the same plan we have in place right now, we left that in place, we're looking at over $300,000 for the county's portion versus with this, going with this option, we're looking at 138,000.
Yes,
more or less.
well, the 306,000 is if the county absorbs the entire increase.
Exactly.
Yeah.
Yeah.
And also the entire employee portion where the employee pays zero.
Okay.
And some counties do that. Well, a lot of counties do that. So I just wanted to show that as an option.
But this plan is that 138,000 is going to save the employees money also up front.
Yes,
And maybe they can put that aside with the idea.
of the higher deductible, yes. And I just want to say with all this, it's estimates, it's not exact numbers,
Right.
but I used it based off the numbers that we have from the last bill, like how many employees were in each tier. So. Anything else? Okay, thank you.
Thank you.
Thank you, Desiree.
Now, this was very good work.
All right, item number 3, provide updates and information on the Aransas County Courthouse. Mark Nell, good morning.
So Mark is going to speak to the majority of the updates that we have with the courthouse, but I did want to bring the furniture. We do need to get that ordered, so I brought the samples and there's some, I believe it was in everybody's packet, but Colin also has it that we can put up on the screen. Just something for you to review. On Monday, we will be asking for a vote so that we can go ahead and get that ordered. And this is the furniture for the 3 courtrooms. The executive assistant to the judge, she does get new furniture because we're taking her furniture and putting it into the district judge's office that they share together. It does not include, we need 2 security desks, one on the first floor, one on the second floor. And then we'll also need chairs with them. And then Indigent Healthcare needs a reception, a taller reception desk. So this is what is included right now. There's going to be some additional items.
Just
you're
so
welcome.
commissioners, though, we are going, every piece of furniture here is going over there. This is
Yes.
just stuff that we don't have.
Right, and a lot of this
Or that doesn't
furniture has been reallocated to other, everything is being reallocated. Nothing's getting surplused at this time. So everything is going to get moved over.
The only
Yeah.
thing I noticed, other than furniture is expensive, is on the core estimate, they charged us tax, but that wouldn't be.
Yeah, that's going to be removed.
Okay.
And it'll be a little bit different when you see it on Monday or when I bring it forward on Monday. The numbers will be a little bit different because they are going to be adding some grommets into a couple of the desks. Those were the things that I sent back to them. As far as the colors of the tables, any of that, that's just the same cost. But putting in a grommet, I asked them to do that on 6 tables, I'm sorry, 2 in each.
Is that where you put the computer cables or what's it? called?
Correct.
Okay.
Right. And so it's for the 2 bailiffs' desk and for the court reporters. So their cords can go through the desk instead of hanging over the front of the desk. So that's a minimal fee.
So these chairs are not going to be used in the new courtrooms though, the chairs that are in here.
Right. These, I believe, are supposed to be going to the community building.
Oh, okay.
So everything will get pushed somewhere. The community building does not have any furniture.
Can we use these desks for the bailiffs? Or they're already going, the ones in the corners that the sheriff's at?
Where Alma sits sometimes.
You probably could. I'd have to measure them and see the size of them.
Okay.
Because those courtrooms are minimal size. And the tables that we have currently that are on this order are ones that can be rolled away if not needed.
Okay.
So they can be pushed out so that
Just-
they would make more room.
For everybody's understanding, this courtroom here is actually larger than our courtrooms at the courthouse.
Correct.
Much larger.
Correct.
Twice as large. This courtroom is twice as large as the courtrooms in a new courthouse.
Is it twice?
Right at it.
Well, we'll be closer.
There won't be so much distance. You'll feel my breath.
Oh, man. All right, well, all right. Any questions concerning furniture or, all right,
Okay. And then Mark will speak about
Mark.
the updates.
no, we got.
Hey, good morning, Judge Garza,
Morning, Mark.
commissioners, other participants. I just want to give a brief update of the project today. As it stands now, we are 8 weeks away from August the 9th. That's 40 working days. This report basically is an account of my visit on Monday and Wednesday during the storm. I wanted to see how well we fare in the interstitial space above the usable spaces on the second floor. So I want to look for water intrusion. So it was a perfect time to do that. So I noticed on Monday, which was the 16th or the 17th, sorry, they had 5 guys working on data cabling. TM Work Zone was there doing some brickwork. They had about 5 employees. Sharp Glass had 2 employees there, and the truss repair crew was there on Wednesday. So we didn't have them on Monday. So we had a total of about maybe 12 people on site, and none of the ceiling tile was being replaced. The ceiling grid, I was extremely alarmed knowing that a project of this size should be covered up with people getting it ready for the due date. So looking at the concerns, as I said, no apparent ceiling tile replacement has begun. We talked about that in the last project meeting and also in the meeting before that during our owners meeting. We still have wet ceiling tile around the tower. There's damaged grid as well as the tile. So the grid that holds up the ceiling, if it's bent, it needs to be replaced, because when you go down and buy a new car, you don't expect to receive it with a dent in it. So my opinion is that should be replaced. No floor protection in the corridors. All of that laminate floor is getting abused daily by workers dragging tools and equipment through there. And a lot of that floor is gouged badly. And I've talked to Jacob and to Justin about that, and they said they're going to replace it. But I mean, time is growing nigh. It is time that they start doing these replacements of some of these components. We have carpet tile that's not adhering properly. The ends are curling up. And I've pulled up some of the tile just to see what the reason was. And there's still debris under there. And I've got photographs of it, of like sheetrock mud and dirt and debris, that it wasn't properly cleaned before they put the glue down to put the carpet on. And that's not in every case, but it's in several rooms. So I don't want to alarm you and say the whole building carpet is not good, but some of it is.
Mark,
The break room.
if I could interrupt you, you're our proponent. Would you tell us what you're doing to mitigate this?
Every project meeting, I am on them like white on rice.
Okay.
And it goes on deaf ears most of the time. And I get argument from them. But yes, I'm instrumental in instructing them on what needs to be done.
Okay.
And then it always ends up in an argument.
Okay.
The break room has excessive amounts of overweight stored material. They're storing, I think it was about 40 sheets of plywood, 3/4 inch plywood stacked on 2 runners in the break room. And that laminate floor is getting just destroyed. The north stairwell, you can see the pictures. That has so much work to be done.
We don't have any photos, do we?
Oh, it's in the packet, Commissioner.
It's in this packet here.
No.
We didn't get a packet. I don't think, unless we got it this morning in
No. I picked up that packet this morning.
Well, Mark has copies.
I have some more. I have some more if you need them.
project manager's update.
Yeah.
That's it, yeah. So as I said, the north stairwell requires a ton of work to get that in shape. It hasn't been painted, the floors are in disarray. There's a window in there that needs to be covered. I've found apparent scratches on the brand new elevator doors.
Mark, can I get a
that's
copy?
really
Oh,
hard.
there, she's got it. We got it.
Ceramic tile in the bathrooms, I find that it's not flush. It's poorly laid, and I compare that to the work that was done over in the city hall, same tile, and it's much different. They had a different tile installer over there. There's also debris scattered throughout the building interior. Doors and frames still require completion. Some are disfigured. They beat on them to install them, so the hollow metal frame is beat, dented in. Some windows don't have insulation and wallboard covering, such as in some of Collins' areas. All of the windows are missing their interior stools, which is the bottom part of the window. And I talked to Justin, he said they were going to start that Monday. So we'll see about that. Toilet accessories are still, some are not installed. The roof is leaking. The root to brick interface at the tower, where the tower penetrates the second story roof, that seam has never been sealed because they're waiting to get the brick to go up through the brick has to rest on the concrete slab of the second floor roof, and it penetrates that sheet metal roof. And when it does, they'll flash it. But in the interim, they've got a temporary seal there, and we're constantly getting water dripping down into those rooms adjacent to either side of it. The louvers, I sent out an email. I think I copied you, Judge, and Elle, about maybe a month ago or 2 months ago to Jason. And I just told him, I said, Jason, those louvers are not installed properly. I said, they haven't been back wrapped. And of course, we got into an argument, and he said he was going to call the roofing company to find out the way to seal them. And I told him the roofing company is not the architect of record. They need to be the person to decide how those are installed. And it never got repaired or fixed, and now they're leaking profusely in the attic. So the trusses that rusted due to water intrusion, trusses all along that eastern side of the courthouse facing the parking lot, are now sitting in water. And this is a G60 galvanized. It's an electroplated galvanized truss, so it's not hot dip. So they're meant to stay dry and they'll perform well. But once they get wet and air dry and they get wet again, or if they're trapped with moisture on them, they begin rusting. It's just an electroplated galvanization. It's not meant to last. So with that said, we cannot install this attic insulation until this louver problem is fixed. Otherwise, this water gets under the insulation, then it's trapped for good, and then the trusses really fall apart. So I want to make sure that Justin and them know that they, and I'm just a little bit disgusted that they've pushed all this stuff to the end of the project, hoping you'll accept shoddy workmanship just to get them out of here. And I'm afraid that's where they're going with this. I just don't have a good feeling about it. And then on 6/19, same thing. I was in the attic during the storm, and I noticed all this water intrusion through these louvers. The clock tower, that opening for the clock towers, wide open, no protection whatsoever for the storm, the incoming storm. We knew about the storm several, 3-4 days in advance. No preparations were made to seal any of that. And we had about a ½ inch of standing water in that tower floor when I was in there. The open soffit, the slot around the soffit on the roof line, that's open. We've got pigeons living inside the attic now, and there's pigeon droppings in the attic. The tower windows are not installed. We had large amounts of water coming in there also. And then there's some structural studs that are not attached to the structural beam that we had put in by change order. And that structural beam is meant to, the studs were, say for instance, this long, they exceeded the allowable bending and deflection limits for that stud. So what we had done by change order is put a big steel tube around the tower and anchor it off to the studs. Well, that's never been done. The tube's there, but they haven't anchored it to the stud. So during heavy winds, that's going to deflect. And any work they're doing on that tower, if it deflects, it could crack it and cause water intrusion.
How long have you been aware of this?
I'm sorry?
How long have you been aware of this?
I've
Working with them?
I've got it in many reports.
Okay,
that
okay.
I asked them repeatedly to anchor this tube to these metal studs. And I've got documentation to show it.
Okay, thank you.
And then the last thing is, I don't believe Teal will be ready for substantial completion August the 9th. And then following that page, I have a list of photographs.
Do you have any kind of an idea of a approximate date you think things could happen from your conversations with them
Well,
and
they
be?
told us they're gonna make August the 9th, but I just don't see a diligent effort on their
Okay.
part to get us to that point.
Any other questions? All right. Like to add anything else, Mark?
I'm sorry, that's all.
Okay.
Elle, did you have anything else to add or?
Mark's report, I was there, I've been asked to go basically once a day. And what I'm doing is I'm just looking at the number of employees that are on site, just calculating, just getting those numbers. So I've been recording that, we have had masons on site pretty much regularly. Nobody's doing the interior of the buildings. Right now, Jacob, who used to be our project manager, is not on site. I haven't seen him for about 2 weeks now. Yeah, I believe he's moved over to another project. We do have a new boy, young man, Hagan. He's an intern for the summer, so he comes on site and does the walkarounds with us. They are making progress on the exterior as far as the tower. I believe that they're going to be done probably in the next 20 days with getting the masons, and that's why they're working so hard on that. With the new rainstorm coming next week, I'll be interested in seeing what happens. Judge, myself, and Renee, we did a walkthrough yesterday morning at 7:30 a.m. right after the storm to kind of see what was going on. I was a little surprised because there was not as much water damage inside the building as I had expected. So I thought that was good. But the conference room that's upstairs, which is right under the tower, the whole entire carpet is wet. I did take videos, like you can squish your foot in the carpet and water will come up. So I'm hopeful that we will be ready in August. I'm hopeful that they're perhaps watching this and they will pull it together and get more people on staff. On
Are they
site.
online, Colin? So no one from Teal is represented on YouTube or anything? Okay, thank you.
Mhm. So, and I will be taking a tour today at 1 o'clock.
All right.
Thank you,
I
Elle.
do have a question for you, Mark. I believe our contract says that we can request more workers on site. Have we done that yet?
Mark,
Mark,
would
can you
you,
come to the
yeah, the
microphone,
microphone, please.
We've asked them to provide more supervision. We've asked them to be on site for their subcontractors, should their subcontractors have questions. We've asked them to increase the amount of employees they have for different tasks. Yes.
I think there's also a contract term where you can formally object to the project supervisor who's there. So if we would like someone who's not an intern, and perhaps someone who carries some kind of certification, there's a mechanism to do that.
I'm not aware of that. I'd like to get with you and find out what that is.
Yes, absolutely. Second question, do you have a copy of all of the subcontractors' contracts by any chance?
No, we're not afforded that. That's a private contract between the contractor and subcontractor.
Do you mean because Broadus does not have a direct contract with Teal?
Right.
Okay, because
Well,
our
we're not-
contract says we
I don't
can.
think you guys have a copy of the subcontracts either.
Well, I know we don't have a copy of them, but our contract says that we can, and they have to get written permission to hire them anyway, but I don't think they're following that contract term, which is why I was
Another
asking.
important thing that I think we should be afforded is a copy of the recorded meeting minutes.
Okay.
And I've asked for those. I've asked for job field reports, daily field reports, and they have this website called Plan Grid, but they've told me they're on Plan Grid, but I've been on Plan Grid and I've asked them to show me where they are. And I was told I don't have permission to get to the daily field reports, and I've asked them to
We
allow
do.
me permission.
Okay, a better way of saying it is the contract says we do. And our contract with you or with Broadus says that y'all are our designated representative. And so hypothetically, the owner or the owner's designated representative should have access to that as well. So if we can maybe touch base after this meeting,
I think what I'll do is I'll follow up with an email to Justin and to Teal Construction and just say we want a copy of all recorded
Mhm.
owner architect meetings, and we want a copy of all their daily field reports.
okay.
I think there's an email that Heaven said that it was on, that what your request was on Plan Grid, it just wasn't published. So,
Yeah.
Okay, and if it
So I
helps,
don't
I
have
can write
access
that
to it
email
either
for
way.
you.
so you don't have access.
Yeah, I can write that email for you because we have the rights under the contract. Because Broadus doesn't have a direct contract with Teal, that might be why, but I can, if nothing else, I can provide you the contract terms that specifically say.
I would
We can.
appreciate that.
The microphone.
Microphone.
Trusses in the courthouse are not correct for an open air design, which is what it is. Will the metal trusses be coated or replaced?
Can you repeat that at the microphone, please, Renee?
Since the design of the roof is open air, right? And they've got truss metal in there that's not supposed to be in an open air design. So something's got to change, the louvers or the metal. Will that be changed? And which would be changed
Well, the
or
G-
coated?
The G60 coating that's on those trusses is completely adequate, provided they don't get wet.
Mhm.
So the seal louvers is the key to keeping that attic dry. So once the louvers are sealed, the soffit vent is underneath the roof, so we're not gonna get an intrusion of water. So the G60 coating on those trusses is an adequate coating. But-
So
and
the
they have-
condensation is
we shouldn't have condensation once they get that urethane foam insulation put down.
perfect. Thank you.
Is the lifespan of those trusses, has it been compromised for the lifespan of compared to the lifespan of the courthouse?
That's exactly a that's a very good question. So we made a report, we took photographs, there were rusted trusses up there. So we had the contractor contact the truss manufacturer, find out what needed to be done. I suggested they replace the bottom cord of the trusses because it was sitting on top of the concrete. And some of the area around the tower, it was isolated to around the tower where we have intrusion of water. Those bottom truss cords, which is the bottom part of the truss, sitting directly on the concrete, they began rusting. So it was about 20 trusses, I believe. So the truss manufacturer sent in a repair for those trusses, and what it meant, the repair contained a directive to cut out the rusted section and to replace the cutout section with another section that spanned, I think it's about 18 inches onto the remaining truss on either side. So we have new screw attached bottom cords, and they were up there during the rainstorm doing that while I was there. In fact, they're in some of the pictures, I believe, in that photo log that I sent you. But that's an adequate repair, and they're signed and sealed by their engineer. They have their own engineer, that truss manufacturer. So if he signs off of it, I can't very well override what he says.
Thank you.
All right. Anything else? Okay. Well, thank you, commissioners, for being here, and I'll entertain a motion to adjourn.
I move we adjourn.
Commissioner Cheney, Commissioner Casterline.
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
and Judge Gladstone.
Aye. Thank you. Thanks, guys.